Hello everybody, I'm Sachin. Today I'm here to presenting about the doctrine of privity of contract and expectations, Indian versus English law. As our academic purpose, I'm presenting this topic in front of you all. So let us look at what is the meaning of doctrine of privity contract. So no one may be entitled to or bound by the terms of a contract to which he is not an original party. In other words, the rights and obligations are strict to private matters or contracting parties, and because of this, a stranger has no legal access to them. Thus, the doctrine of privity of contract means that a non-party cannot bring any actions to the contract, which means the whoever persons having a legal contract between each other, the person the who is third party, he cannot enter between of them. So private of the privity of contract has three broad effects. First one is that a third party cannot receive a benefit if he is not a party to that contract. The second point is that a third party cannot be liable under the contract if he is not a party to that contract. The third point is that the third party cannot enforce a contract if he is not a party to that contract. So, in simple words, generally speaking, a person will be regraded as a being privy to be a contract if that person entered into an agreement. For example, that person made a promise in exchange for another party's promise. So, and that person provided consideration in support of the agreement. So here there are two implications. First one is that a contract cannot impose an obligations, which means burden on a third party without that party consent. This is burden. And the second one is that right, where a contract confers a benefit, that is right, on a third party. That party cannot enforce the contract. So the legal issue of privity of the contract becomes important when two persons have entered a contract, and by the terms of that contract, so a benefit has been conferred on a third person. So it clearly says that the privity does not prevent a contract from configuring a benefit on a third person. It simply prevents the third person from enforcing the contract. So there are three points which it comes under this. The first one is that central to the rules of privity contract, therefore, is identifying the contracting parties. Second one is denies third party to enforce right. The fourth point is that best argued that the third party is a party to the agreement. Yeah.
Hello, I am Vicky Kumar R, and here I am there to introduce the conflict, that is limitation and exception. So why cannot third parties enforce the contract under strict privity? That is because the traditional rules assume that the contracts are betrayal and the third parties lacks consideration, that is value of exchange, to claim that right. So how did this real world cases expose the flaws in this doctrine? So for that we have a case, one from England and another from India. In England, there is a case of Biswick versus Biswick in 1968, where a widow cannot enforce a contract for her husband pension until the court used the equitable remedies. And in India, we have another case of MC Choco versus State Bank of Travancore in 1970, where the Supreme Court denied a third party right to sue, highlighting rigidities. So, what exemption emerged to fix these gaps? One is the common law, where trust, agency, collaborator contract are more important, and another is equity, where specific performance of benefit are important, that is family agreements.
Coming to the part of comparative plot, Indian versus English law on privity of contract. Indian law adopted the English privity of contract rule through the Indian Contract Act 1872, especially Section D of dues on consideration. This reflected colonial legal transplants only parties to a contract could use. However, divergency came later in India. Court Crawood judge made exceptions, for example, under Section 88 of the Indian Trust Act 1882 for trust and in family settlements. In England, the Contract Right of the Third Parties Act 1999 made a major statutory reforms allowing third parties to use if expressly provided. Who shaped this change means in India, judge expanded expansions case by case like in Srimati Sharadamani Kandappan v. S. Rajalakshmi 2011 and Kawaj Muhammad Khan v. Usani Begum in 1910. In England, Parliament codified third parties' rights in 1999, reducing resiliency on court made exceptions. Thank you. The next part will.
When can third parties sue in India? First one is trust. If the contract creates a trust, that is money or property is held for someone's benefit, the third party beneficiary can sue. Second one is beneficiary contract. In family agreement like marriage settlement, a third party family member can enforce the contract. And the third one is agency. When the contract act for someone else, the actual principal can sue or be sued. Some example for this is contract made for minor children's benefit by parents can sometimes be enforced by the child. Next one is a life insurance policy taken in the name of another person. Next, when can third parties sue in England? A statutory right act 1999 under the contractor. If the contract expressly says a third party has a right, they can sue. And a common exceptions are a trust agency, which are same as a Indian. Examples are if a company promises to supply goods directly to a consumer's client, the client may sue under the 1999 act. And a tenant can sometimes enforce landlord promise made to previous tenant. How do these exceptions reflect each country's legal priorities? In India, focuses more on equity, fairness, and social justice, especially in family and trust situation. In England, focuses more on commercial certainty and clear rules, except especially through written status.
Hello everyone, myself Arun. I am going to tell about resolution impact and modern relevance of England and India. England law clearly helps business easily that includes third party. In England, business don't worry much. They can name third party directly in contracts because of their 1999 Act. It reduces risk and make contract enforcement faster and smoother. If a third party needs to sue or claim benefits, the law already supports it. Business avoid delay and extra court fights. But in India, it's different. It's clearly opposite. No clear status yet. Business must find creative ways. In India, it doesn't have a law like England, so businesses must use strict to like trust agency or assignment to protect third parties. More certainly, it leads to longer negotiation and legal disputes. Contracts take longer time to draft and disputes, and which are more common because there confusion about third parties' rights. And it increase for businesses who must draft very detailed contracts. Company must hire expensive lawyer to write complicated contracts that cover all the risks. What are the future reforms? What can improve this situation? India could pass a law similar like England 1999 Act, which is a simple and clear law, would allow third parties to enforce contract easily and clearly allow third party rights in contracts, reduce dependency on courts to create expansions, save time and legal cost for business, which make shorter contracts fair dispute and which can also save money, increase India attractiveness for global investment and startup. And why does it debate still matter today? Because global contracts involve multiple parties across different countries. In today's world, business in our own country often sign deals that affect people in another country. For example, SaaS agreements often deal with end users who aren't directly contract the signers. End user benefit from software without directly signing the contracts. They need production too. And supply chain involves multiple vendors, distributors, and customers. All need clear rights. And strong third-party rights can build more trust in digital and global business environment. Trust encourages more users, customers, and investors to participate freely. And I am going to conclude. The privacy of contract rules started strictly but evolved over time. Originally, only people who signed a contract could enforce in it. England adopted a modern, flexible system through legislation. England passed a law to allow third party rights clearly. But India still uses court made expectation, reflecting a courtesy and equity dependent approach. Strong third-party rights will help industry like e-commerce, fintech, and gig economy platform. Thank you.